I think that's really where these laws have originated from, and it's the primary focus is consumers who are turning over their information for the purpose of receiving services, receiving goods, whatever it might be, credit card companies, et cetera. Consumers are really have primarily been the focus of these U.S. laws and the European laws historically, but that's shifting a little bit even to the non-consumer and to individuals who are mainly they're providing their information perhaps just for the purpose of getting a job or applying for a job.
Good morning, HR. I'm Mike Coffey, president of Imperative, bulletproof background checks with fast and friendly service. And this is the podcast where I talk to business leaders about bringing people together to create value for shareholders, customers, and the community. Please follow, rate, and review Good Morning HR wherever you get your podcast. You can also find us on Facebook, Instagram, YouTube, or at goodmorninghr.com. Many business leaders are familiar with privacy laws like the Health Insurance Portability and Accountability Act, the Gramm-Leach-Bliley Act, and the Fair Credit Reporting Act. Each of those, when they were passed, were groundbreaking and required significant changes to how businesses stored and shared individuals' data. But information about consumers' interactions with businesses, what you buy from Amazon, what you search in Google, or the information you provide in an employment application, have largely been considered the property of the businesses who collect that data. But that's changing. At both the state and federal level, legislators and regulators are taking action to give individuals more control over information concerning themselves. Joining me today to discuss the growing labyrinth of data privacy laws across the United States is Jason Barrett. Jason is an attorney based in Houston, Texas, and he's the principal and founder at James Consulting, where he helps clients with issues concerning employment law, intellectual property, and data privacy compliance. Welcome to Good Morning HR, Jason.
Thank you so much, Mike. It's great to be here. Thanks for having me.
So let's start by painting that big picture. What's driving all this concern about personal data privacy?
Well, that's a good question. I think largely it's based on a cultural shift, especially here in the United States. I would say that really foundationally, Europe has had quite a significant focus on PII or personally identifiable information going back many years. But it's really only within the last 10 years or so that the US has adopted what I would describe as a more overarching model, like the GDPR, which we'll talk about here probably in the next few minutes. Over the last few years, the US has really adopted that, and there's really been the result of a cultural shift from corporate-owned information to personally owned information and the regulations surrounding that.
What do you think is driving that? Why are the politics and just kind of the zeitgeist around that changing?
I think the stakes are just so much higher. There's so much information out there that's available. There's so many different forums of information. We see on the news so often, Mike, the data breaches that are coming fast and furious. And I think individuals are just fed up, quite honestly, with it. And there's a need for, in the U.S. and other countries have seen the need for more regulation around security and the expectations that companies really need to have imposed upon them to protect that information.
So you talked about PII. So is that personally identifiable information? Is that primarily the kind of information we're talking about, or are there other kinds of information? Well, I know there are. So what are the other kinds of why don't you tell us what PII is, and then into the what that sensitive personal information kind of range is?
Sure. I really do think it kind of falls into two primary buckets as it relates to these kinds of data privacy laws. There's PII, or personally identifiable information. How I describe that typically is anything that you might see on a business card, quite honestly, or on a LinkedIn profile. Someone's name, perhaps their address, even their job title, perhaps any kind of other kinds of location related data that, again, you might just see on a normal business card. And then as you move into sensitive personal information, that's as it would suggest to be, it's information that's a little bit more sensitive, but that individuals might need to provide their employer or other third parties, things like race and religion, genetic data, health or medical information, that's really where you get into that sensitive data. And it's really both of those buckets that are being regulated by these data privacy laws.
And so people put so much of that information online already. And with all the data breaches that have happened, I mean, I'm a licensed private investigator in addition to being an HR guy. And the databases, I mean, in our due diligence projects, or even when we're working in employment related background investigation, it's all out there. I can get, just from, relatively low price databases that, I have to have a GLB or a DPPA, a permissible purpose, but it's all there and it's all been breached at some point. I mean, you can go find my stuff on the dark web. I get alerts from my credit card companies and all these other sources all the time. So if the horse is out of the barn, just how much do you think the average consumer needs to worry about their data being breached or, released and used against them?
Well, there are, to your point, there are so many different notices that we're getting almost on a daily basis about certain kinds of data breaches. It's available in so many different areas, as you said. I do think, though, especially relating to kind of the cultural shift that I had mentioned earlier, as it relates to employers and their need to be aware of these different laws, I do think that there is a need for there to be a real awareness and an education exercise within the employment context. And for individuals, as I said earlier, I think the Europeans in general have been much more sensitive to this and much more aware of this and focused on their personal information and being more protective of releasing that information. And I think in the US in particular, there really needs to be a little bit more protection and a little bit more forethought into the kinds of information that we're generally and have historically just made available, really without asking why. Why do you need this information?
Yeah, I mean, every time I go into my doctor's office, they still hand me a sheaf of forms to fill out yet again,
Right.
and they always want my social security number. There is no reason for them to know my social security number. They got my insurance card, they've got all that, and they're collecting that. And then you can see, just a whole wall of manila folders back there behind them that aren't locked up. And, every one of those has that social security number. So that, that's a data breach waiting to happen. And you're right. Europe is, we do work in Europe for some of our clients, and the data transfer laws in Europe are really pretty strict. And the kind of access you have to is pretty challenging. And so a lot of these laws, though, then are really a lot about making the consumers feel better, even if maybe their data's out there. I don't want to have yet another breach. I don't want, I don't want, I don't want people just willy-nilly sharing my information all over. I think we do have the sense that we've lost a certain amount of privacy. I mean, the saying in the early aughts was, privacy is dead. And I think to a certain extent that's probably true for most people, but we've killed it ourselves. We've put all our stuff out there and made it available. But when we're talking about these privacy laws, these regulations, they kind of categorize people in three different buckets, right? Data controllers, data processors, and then these consumers. Talk about what each of those roles are, who those people are, and what does it mean to be a controller versus a processor, those kind of issues.
Sure, and it's a good way to think about it in terms of kind of the purpose for which these laws are set up. So when you think about it, and I'm gonna describe it sort of from the context of an employment situation. So let's say you're a company and you have those three different roles that we talked about. So from a processing side, it might be anyone, for instance, in an HR role. Or a third party even that's supporting an organization in terms of employee counts, employee reports, the kinds of information that an organization might have with respect to applicants, with respect to their employees, performance-related reviews. So that's kind of the data we're talking about, really for the purpose of managing the business. So the processing is really those individuals that are tasked with helping to manage the information, share the information potentially, make reports of that information in that context. The controller would really be the organization itself, and those that are in a decision-making authority or position, I should say, to decide how we're going to use that information as an organization. How are we going to make use of that information with respect to managing benefits, with respect to payroll, with respect to whatever fill in the blank purpose there might be. It's those controllers that are making that decision. And typically an organization or the company in this particular context will be thought of as the controller. And you mentioned one third term, Mike, remind me, and I can
Consumers. Yeah, just the
consumers,
individuals.
absolutely. Yeah, consumers. First and foremost, I think that's really where these laws have originated from, and it's the primary focus is consumers who are turning over their information for the purpose of receiving services, receiving goods, whatever it might be, credit card companies, et cetera. Consumers are really have primarily been the focus of these U.S. laws and the European laws historically, but that's shifting a little bit even to the non-consumer and to individuals who are, mainly they're providing their information perhaps just for the purpose of getting a job or applying for a job.
And so a data controller would be like an employer who wants to aggregate all their applicant data into a database for statistical purposes. And they decide we're going to do this. We're going to pull all the applicants in and come up with some, things about, general, maybe we're going to feed it into our AI to train our employee selection process. And so here's all our employee information. Here's what the applicant pool looks like. And we're going to use it to train the AI. That's the company making that decision. But then that processor, if they had an HRIS system that made that available, the processor would be the HRS system. Is that
or
the
really
AI system?
Yes, I think the individuals maybe that are working within that data entry or exporting reports or whatever it might be would generally be considered your processor.
Okay.
But I think the HRIS system or those that manage that system would be the best example of a processor from the employer perspective.
So when we talk about GDPR then in the EU, the General Data Protection Regulation, what does it say? How does it control how that information gets used?
Well, I think one thing to think about in terms of the GDPR, because it's really followed through with some of these U.S. laws, GDPR is really based on 7 foundational principles. It's sort of the purpose for which that law was put in place and the U.S. laws have followed. There's the principle of limiting the purposes for which a particular organization might be using information or use it for the limited purpose for which you need it. In a similar vein, there's data minimization, which is only use that data that you absolutely positively need, not throwing everything in the kitchen sink into that data repository. There are the principles of accountability, who ultimately is accountable for managing this data, securing the data. And then on a similar vein, confidentiality and security, that's one of the principles, as well as storage limitation, figuring out how an organization is going to dispose of that data once it's brought into the fold. How an individual can be sure that data is accurate. So accuracy is another foundational principle. And then finally, it's the lawfulness piece is, are you using this data for the purpose for a purpose that is lawful and for which I've provided it to you to use?
And in the employment context, that would be in order to be evaluated as an employee, to be hired, to be managed as an employee. What would some uses that an employer might not think of that might fall outside, that they may, have thought they could use the information for, that might fall outside of that narrow, scope?
Sure. So I think, probably that consumer example is a good example. A lot of individuals, when they're applying for a job, when they're knowing that their organization is going to need to have their information for purposes of managing payroll, benefits, et cetera, those obvious purposes. But let's say an employer decides that they're going to have a collaborative partnership with some kind of a third party insurance provider that wants to make available a certain tool or resource to that employee population that's really not within the primary business practice or relationship of the employer in that third party. It's an add-on, if you will. That can kind of get into that category really of something that was turned over by an individual for the purpose of HR management only, that then moved over into a little bit more of a consumer practice if their employer makes that decision to make the employee roster available to third parties outside of the context that primary relationship is based upon.
And so what are so that's Europe, and except to the extent that a U.S. well, let me ask. Let's say we got an EU citizen who's here on a visa and is working in the U.S. Does GDPR have any impact on employers who are U.S. based for an employee who's currently U.S. based?
I would say yes. Now, admittedly, my approach has always been pretty conservative when you think about the global operations of an organization. And so I would think about it more from the standpoint of where are you operating from a global perspective, not necessarily, well, we only have individuals based in the US and therefore we probably don't need to think about GDPR. If you are operating and you have a business that extends outside of the US, even if your employees are sitting only in the US, I think you absolutely need to be familiar with GDPR. And you need to make sure that you're following the different protocols because of how you're operating on a global basis, including within the EU or the UK.
And you talked about the 7 pillars of like the GDPR's data privacy framework. As far as at the federal level in the US, what rules do we have in place right now? I mentioned HIPAA and GLBA and DPPA, the Fair Credit Reporting Act. When those are all about, protecting people's personal data. Are there other laws at the federal level, or are we mostly dealing with this more at the state level in the U.S.?
Well, of course, as you mentioned, there's the industry or sector specific laws that we're all pretty familiar with HIPAA, the FCRA, the Graham-Leach-Bliley Act. There's the Federal Trade Commission that by and large has been the federal enforcement body as it relates to data privacy on things like children's information, telemarketing rules, et cetera. As you've moved over the years, more and more states have adopted what I would describe as probably focused laws. Initially, for instance, like in Illinois and Texas, as an example, you have biometric Privacy Act laws. A lot of people weren't familiar with the Texas law until there was a very recent large enforcement action by the Texas Attorney General. And that particular biometric identifier act from Texas goes back to 2009. So that was an early adopter. I guess Texas could be seen to be an early adopter in that capacity. So it's really kind of spanned and made a transition from industry sector specific laws of the kinds that we were mentioning now into more state specific laws that are drilling down into a little bit more detail on how organizations are using information, either biometric data or that PII and sensitive data that we talked about earlier.
And let's take a quick break. Good Morning HR is brought to you by Imperative, bulletproof background checks with fast and friendly service. 25 years ago, I founded Imperative to help risk-averse clients make well-informed decisions about the people they involve in their business. Because we don't cut corners, our research is more thorough, and our reporting more robust, our clients make better hiring decisions. However, employers often don't know what to ask beyond price when evaluating a background screening partner. So we've compiled a short list of 6 questions that you should ask any prospective screening partner, including Imperative, to ensure that you understand what they're really trying to sell you. These questions identify the most common ways background check companies cut corners that impact the quality, accuracy, and depth of the information they provide employers. You can review the 6 questions you should ask of your background check partner at imperativeinfo.com/6. And of course, you can always reach out to Imperative to discuss your background check process through our website at imperativeinfo.com. If you're an HRCI or SHRM certified professional, this episode of Good Morning HR has been pre-approved for 1/2 hour of recertification credit. To obtain the recertification information, visit goodmorninghr.com and click on Research Credits. Then select episode 178 and enter the keyword data. That's DATA. And now back to my conversation with Jason Barrett. Talk about the Texas biometric law. What does it entail, and how does it really affect employers?
Yeah, so it really kind of goes to making sure that organizations or anybody that's collecting biometric data, could be Face ID type information, could be fingerprints, et cetera, things of that nature. It goes in and it regulates how organizations are using that and the kinds of information that needs to be provided to those individuals before you collect it. That particular case was pretty interesting that came down. It's actually had gone back quite a few years, but it was a $1.4 billion settlement that the Texas Attorney General entered into with Meta. That goes back quite a few years. And then there's another lawsuit that's pending under the similar law, the same law, I should say, with Google right now.
And that probably surprises people. How are Meta and Google collecting my biometric information?
Right. So that's the thing, is I think they had not been transparent with how they're doing that, and that was one of the findings, as I understand it, in the law and in the penalty. And so much about these laws is about transparency. If you're going to collect this particular kinds of data, you need to let people know. You need to tell them how you're collecting it, why you're collecting it, and the use of that data.
And that's so they were just what were they? They were just collecting what my face looks like, and is that primarily what the biometric information was, or?
Yeah, I think in that particular case, I would need to go back and look at all the dig beneath the surface on all the details of that one. But it was kind of a landmark type ruling that relates to information that they were really collecting without notifying people.
And so now they're probably notifying us, and we're click, yes, accept, and moving right past it anyway. But at least now they're telling us.
Right.
Interesting. So, Texas and California are at opposite ends of the political spectrum pretty much. But, I mean, certainly in the last legislative session, Texas had some privacy bills, and the session starts again in January. And I know the State Chamber of Commerce, the Texas Association of Business, has been working for the last 2 years with Representative Cabriglione's office and other legislators around their, privacy law part 2 from, following up from last session. And then California obviously has had a lot of issues on the privacy front too. What are typical, state level privacy things that you see are kind of cutting edge between California, Texas, Florida, whoever else is having those? What do you think we're going to be dealing with in the next few years?
Well, I think the Texas Attorney General, for one, has kind of signaled with that particular finding that we just talked about that they're going to be aggressive. And there was a recent conference where they all but said, get ready. We're going to be looking to enforce these particular laws, including the Texas Data Privacy and Secrecy Act. There's also the Texas Data Broker Act that went into place more recently, and that's more focused on consumers, as we were talking about earlier, and organizations that collect information really for the sole purpose of monetizing that particular that set of information. But I think probably the primary focus area is going to be what kind of notifications, what kind of communications and transparency are organizations that collect this information providing to consumers or to the individuals or the data subjects that they're collecting. It's going to be really key that those notifications are made. There's privacy policies that are communicated, that individuals are given the opportunity to opt in as it relates to the collection of that information, especially on the consumer side. But I think it's going to be primarily a focus on communication, transparency, and notification as it relates to any individual, whether they're an employee or a consumer, turning over that information.
And I think the Texas Data Privacy Security Act exempts, and correct me if I'm wrong, I'm thinking that from the, remembering the conversations during session, is that it exempts information that's gathered and used for employment by employers. Is that right? Or
there is an exemption if it's truly just used for processing for employment, compensation, et cetera. California had a similar exemption, but that was sunset with the newer law that went into place, which was kind of took folks by surprise. There are other exemptions under Texas law, including organizations that are nonprofit, small businesses, as an example, as defined under the Small Business Act, as well as other organizations that might already be regulated under laws like HIPAA or some of the banking and consumer laws. And so with the idea being pretty straightforward that you don't want to duplicate or overreach in terms of organizations that are already covered by some of those other laws. But so there are exemptions in those particular cases.
But that doesn't mean that an employer who has applicant information or employee information can just go sell that information, that PII or that sensitive data about their employees to a third party for marketing purposes or whatever else, right?
That's correct. Yeah, I think that's still going to potentially be something that might be covered under the Texas Data Broker Act if you're moving into territory that was previously really just for collecting for the purposes of HR administration, and then you're moving it into a little bit more of a monetization exercise. That's going to be a pretty high risk scenario, in especially with these new laws.
So if we're dealing with, let's say we're a Texas-based company, we're dealing with a consumer who lives in Iowa, which states' data privacy laws apply in those circumstances? If you've got two states with different, or California and Texas for that matter, two states with different laws, how does an employer know when, which laws apply? Is it, if I'm considering it, let's start with the applicant who lives in California is moving to Texas for the job. If they get the job, does California's privacy law apply to them because they're a resident of California, or does Texas?
I would take the approach of both. Really need to look at, out of an abundance of caution, both, because there are so many different things that are the same about these laws, but there's also some overlapping implications as well. And the other thing, certainly, if you look at it from the perspective of where an applicant or an employee is based, yes, that's one differentiating factor, but you also have to look at where the organization has operations. If you have an organization that might have employees in 6, 7, 8 different states, but operations in 47 or 48 different states, you really have to look at how those particular states interact with each other in terms of data privacy laws and other aspects that might regulate that particular data privacy matter.
So you're looking kind of at to be safe, the lowest common denominator or the most strict rules and just applying that?
Absolutely. And that's kind of, the approach that I've taken in my history with different organizations that I've worked for is we've recognized that, okay, well, wow, we operate in these however many different countries. Where do we start? Where do we begin? How do we look at this from a compliance standpoint? And what we ended up doing was kind of, to your point, we looked at what's the most prescriptive, what's the most overarching and broadest regulatory regime that we might be operating in. And if we can comply with those particular laws and regulations, that we feel comfortable that we're going to be in a much better position globally.
So if I'm an HR leader or just the business who has these employees, I probably have information in a bunch of different silos, right? I've got applicant tracking information, then I've got employee information in my HRS. Maybe I've got a separate payroll provider who's got employee information. Maybe my benefits, or I've got a system for managing our health insurance that maybe my broker provides. How keeping track of what data is where and how we're categorizing it. Are there best practices to kind of get your arms around where the data is and making sure that you've got some accountability for it?
Absolutely. And one thing that I would recommend is that whomever is going to be responsible for your data privacy, your data protection in your organization, really takes a deep dive into understanding, really it's the who, what, when, where, why, and how of data within the organization. And in terms of the where, as you were mentioning earlier, there could be many different applications, many different storage facilities, et cetera. where this data is housed. And so probably early on, if an organization hasn't started to do this, and especially if they're growing by acquisition, you've got multiple other third-party companies that are now becoming part of your organization that might have different systems, might have different individuals that have been responsible for this. I would say start there, is really try to come up with the data mapping as best you can for what data you hold, why you hold it, and who has responsibility for it. And then certainly to your point, you have to know where it's stored for purposes of putting the best data privacy regulations in place.
Because of the data providers we work with on the background investigation side of our business, one of the things that we see a lot is that certain data, we keep data in certain different states. That we've got data that's active, then we've got data that is, for all intents and purposes, we'll probably not ever need to access. We've never needed to access before, but we keep it for up to 7 years for litigation purposes, and that's in an archive state. And then at some point after that, depending on what the data is, we may delete it altogether and not record it. Do the laws address that, or are those just kind of standard practices or best practices for deciding what information to keep on hand and where to keep it?
Well, the laws address that in, I guess, two ways. One is putting requirements out there that share and provide notice to individuals or data subjects on why the information is being collected. And then the second kind of goes back to one of those foundational principles that I mentioned earlier with the GDPR that's followed through with these US laws. And that's the principle of data minimization. Only maintain that amount of data. The question that some of these regulatory authorities will ask is, are you only maintaining the data that you absolutely need? Not the nice to have data, but also, the have to have, primarily looking at that from a data minimization perspective. So you might have information that, to your point, that's spread out all over different states, perhaps all over different applications. But there's really a need to do a deeper dive and analysis of the data minimization piece and, who has access to that information.
One of the things I know GDPR gives consumers or individuals is the right to, in some cases, the right to be forgotten, and in other cases, just the right to have access to know what's being stored. Do we have any of those kind of rights in the U.S.?
Yes. Yeah, similar rights have transferred over into these U.S. laws. There's the rights to, some of which you mentioned, the rights to access. If I'm an individual, how do I access my information? Where are you holding it? How do I correct it? How do I take it with me? If I'm leaving the organization, I want to make sure that it's coming with me and that there's not an unnecessary need for the information to be retained for too long of a period of time. There's also these rights of notification of how the information can be deleted and who has access to the information. So these notification rights have really transferred over into the U.S. data privacy laws as well.
And from an employer point of view, the answer, except with the exception of a few states, when an employee wants a copy of their employee file, the answer's always been, that's employer's property. No, you can't have a copy of your, especially a departing employer. Has that changed under any of these laws?
To some extent, I would say that generally speaking, that an employer can still say, look, that's our employee file. Yes, it's your information, but that's information and it's a file that we need for purposes of processing employment, including someone who's leaving the organization. Now, where I think may have changed a little bit is there can be a data access request under most of these laws where someone can come forward, whether they're moving on or whether they're still with the company. They can make a data access request to say to their employer, look, I want to see what information you have on me. And there's nothing that says that an employer can't say, fine, come into this office, have a look at the information. It doesn't necessarily mean you have to, make a copy of all of their files and provide it over to them if you're concerned in that respect. I do think that companies need to be more aware of those kinds of protections under the U.S. data privacy laws, because it's a little bit of a new scenario. Typically in the U.S., that would really only come up in the context of litigation, where someone might be suing the company. It's a third-party subpoena that comes in through an attorney. But in this case, with these laws, it can be the individual themselves, him or herself, making that request for information. And it's important to make sure that organizations know who's going to be the point of contact and what are the different do's and don'ts as it relates to those requests.
And right now, that would be a state by state basis, right? Figuring out what the applicable laws wherever you are. So if you're in Texas, you have to look at Texas Data Privacy Act versus California's multiple acts, or Virginia, or wherever you are, and try to figure that out as an employer, which is, the problem with, a federal system where we got 50 states regulating issues. It's harder for employers who are operating in multiple states to know exactly what they need to do.
That's right.
But I brought up AI earlier, and let's end with this because we can't talk about anything today without bringing up AI. So what do you think the impact of AI is going to be on data privacy? We want all this data to train these large language models and all of that, but obviously nobody wants their data. They want to use the tools, but they don't want their data in their training the tools.
Right.
So where do you think that's going? What are you seeing on the AI front? I know California's had a lot of concerns, but Governor Newsom vetoed their AI bill this week. So what do you think is going to happen with AI?
Well, I think to your point, AI is most definitely here to stay. So it's a matter of how do we manage that? Somewhat like we were talking about in terms of the GDPR making its way to the US, I think the EU and the UK right now are kind of at the forefront as it relates to putting regulations in place for AI. There are some laws that have been passed over there, and I'd say some best practices. The states have not yet made, to your point, California, again, kind of being the pioneer as it related to the GDPR moving over into their state law. I would expect, they'd probably be leading the way in many respects in terms of the laws for AI over in the US. I think that there are so many states considering that right now, and things being considered at the federal level as well. I think companies, realistically, we know that they're going to want to continue to leverage AI. I think it's just a matter of keeping those same foundational principles that we talked about earlier at the forefront of your mind in terms of making sure that you're maintaining it for the right purposes, that you're allowing employees to know what is being collected, and that you're being very transparent with your employees, and then on the consumer side with consumers about the kinds of information and the purposes for which it's being collected and managed.
Well, great. Well, that's all the time we have. Thanks for joining me, Jason.
Thank you for having me. I really appreciate it.
And thank you for listening. You can comment on this episode or search our previous episodes at goodmorninghr.com or on Facebook, Instagram, or YouTube. And don't forget to follow us wherever you get your podcasts. Rob Upchurch is our technical producer, and you can reach him at robmakespods.com. And thank you to Imperative's marketing coordinator, Marianne Hernandez, who keeps the trains running on time. And I'm Mike Coffey. As always, don't hesitate to reach out if I can be of service to you personally or professionally. I'll see you next week, and until then, be well, do good, and keep your chin up.